partnership. So what will be the learning objectives of this lecture? We will cover the definition and essentials of partnership. We will also look the difference between partnership and co-ownership. Then we will see the types of partnerships, and then we see the types of partners. So what is the definition of partnership? Partnership is a relationship between persons who have agreed to share the profits of business carried by all or any of them acting for all. So if we have all the partners have provided an attorney to one person, so that will be also known as a partnership. So it is not necessary that there must be 20 members. So all the members, if they are agreeing on any deed or the document signed by them to provide an attorney to one person, then it will also be included into the partnership. So what does the third party means? Third party means any person who is not partner in the firm. Then we have the act of the firm, means act done by a partner which gives right enforceable by or against the firm. So if any act will be given by the partners, it will be done by partner which gives right enforceable by against the firm. So it will be the right against the firm. So either he are making the profitable or not, but it gives the right that will be enforceable by the firm. So then what are the essentials of partnership? Partnership, there exists the agreement between partners. Then there we have the association of two or more persons. Then we have the agreement to carry on a business. Then we have the sharings of profits. Then we have the mutual agency. Then we have the no separate legal status. And then we have the unlimited liability. So let us discuss what the agreement between partners shows. Partnership is created through a formal agreement called partnership deed, which may be written or implied. So it is not necessary to have it written or oral. It can be also from the conduct of actions. So then we have the partners do not arise by status, family. What does the status means? Family, inheritance, or Hindu undivided family. Then we have the association of two or more persons. There must be an association of two or more persons. At least two persons are necessary to form a partnership. So if one person is providing attorney to one person, then it will also be counted as a partnership as per the definition of partnership. Then we have the all partners must be legally competent to contract. They must not be unsound mind or the minor or the person disqualified by law. Then we have the maximum number of partners in a partnership may be 20. So there exist separate industries. In banking sector we have the maximum number of partners equal to 10. In profession firms, number of partners can exceed to 20. If number of partners exceed these limits, partners become a legal association. So if they will increase the 20 numbers, so certainly it will be the corporation, not the partnership. So it shows the legal association. It's not a partnership. So agreement carry on a business. Partners must engage in a business activity. Examples where no partnership exists, like charitable works. If any partnership doing the charitable work, so only charitable activities do not qualify as partnerships. All the charity work will not be qualified as a partnership. Then we have the rental income sharing agreement solely to share property. Rent do not form the partnerships. So it is not the part of partnership. Then we have the sharing of profits, how the profits will be shared. Usually sharing of profits indicate that a partnership exists. However, in following cases, profit is shared with the person, but he does not become partner. So there exist certain cases in which the profits are not shared with the profit, but he cannot become the partner. A lender who lent his money to a business, for suppose bank, an employee or agent who receives share of profit as remuneration, who gets the salary, a retired partner or widow, or a child of deceased partner who receives an annuity or the payments based upon monthly or annually. Then we have the previous owner of business who receives share as consideration of sale of goodwill or business, a minor who is admitted to the benefits of an existing partner, a transferee of partner's interest. So this is how the sharing of profits is an essential of partnership. Then we have the mutual agency. Each partner acts as both an agent and a principal for others, meaning one partner's actions can bind the others. So in partnerships, the agent is also a partner, but the principal is also a partner. So the partner's actions can bind the others. So all action of one person have to be accepted by the all the partners. So no separate legal status. Single identity partnership do not have separate legal status like companies. Third party agreements. Any contract with partnership involves all partners personally. So they have the unlimited liability. Partners have joint and several liability. Every partner has unlimited liability for all debts of partnership. Creditors may compel any partner to pay the whole debts of firm. So I hope you understood the essentials of the partnerships. Now we are moving forward to the difference between partnership and co-ownerships. So by formation created only an agreement between partners, whereas ownership shows may arise through agreement or inheritance. So ownership can be from the inheritance. Suppose your relative is a king of any country, then you will get the inheritance. As there is the kingdom system of Saudi Arabia, then he will be the next king. But the partnership is in agreements between the partners. So business requirements, conducting business is essential in a partnerships. So if you are in a partnership, there must be a business. So if you are in a co-ownership, it does not require a business activity. So it is not necessary to have a business activity. Partners can be based upon a personal activities, or co-ownership can be based upon a personal activities as well. So then number of partners is minimum number of 2 and maximum of 20s, but in co-ownership we have no limit on the number of co-owners. So in profit sharing, the profit sharing is an essential element of partnership, but in co-ownership it is not necessary that the profit sharing should be there. Then we have the agency relationship. Each partner acts as an agent of the firm for business purposes. Co-owners are not agents for each other. So now we are moving forward to the types of partnerships. So there are two types of partnership: particular partnership and the partnership at will. So what is the partnership at particular partnership? It is a partnership which is created for particular period or project. Partnership for producing a film. So suppose it particular partnership is based upon the projects. They will be completed within the shorter period of time. So it is not necessary they must be going activity. So they can be end within the shorted limit of time. Then such partnership is dissolved on completion of project or an expiry of period. No notice of dissolution is required. If partnership is continued after completion expiry of time, this will become partnership at will. So partnership at will is a partnership in which period or project is not specified. Any partner can dissolve the partnership by giving written notice of dissolution. If date of dissolution is mentioned in notice, it will be dissolved from the date. If date of dissolution is not mentioned in the notice, it will be dissolved from the communication of notice. If agreements state that partnership will be dissolved only with consent of all partners, this will not be a partnership at will. So I hope you understood the essentials of partnership and the types of partnership. So we will cover